Now, we begin this hour in Florida, where earlier today, defendant Alexander Deltoro rejected a plea deal in his murder case.
Deltoro is accused of fatally shooting his mom, Cindy, while she was breaking up a fight between him and his father.
Deltoro claims that he shot his mother by accident after he noticed his father reaching for his gun.
Now, Deltoro denied the state's plea offer, which would have given him 10 years probation. I'm shocked. And now he actually faces 10 years behind bars.
Yeah, it's really something. For more on this case against Alexander Deltoro, here's Court TV legal correspondent Kelly Craft.
Alexander Deltoro Jr. is accused of fatally shooting his mother, Cindy Deltoro, on December 14, 2019. Deltoro shot his mother when she broke up a fight between him and his father, Alexander Deltoro Sr. They had all been out for Jr.'s 28th birthday. According to the police affidavit, Jr. and his dad began to argue on their way back home. Deltoro Jr. ended up hitting his father in the face with his arm. It is unclear if it was accidental. When they arrived home, the father and son began shoving and pushing each other. Deltoro was pinned to a concrete wall by his father and lost his glasses in the struggle. Then Cindy Deltoro tried to break up the fight. According to the affidavit, she was able to separate them. But in that moment, the defendant produced the firearm, pointed it in the direction of his mother and father, and discharged a single round. The bullet hit Cindy Deltoro in the face and killed her. At a Stand Your Ground hearing in May, Deltoro Jr. told the judge that he was afraid for his life. He testified that he saw his father put his hand into his pocket and that he knew his father was reaching for his gun. Deltoro says he pulled his own gun out for protection, but never meant to shoot it, and that he accidentally shot his mother. The judge ruled it would be up to the jury to decide if Deltoro Jr. accidentally shot his mother in self-defense or not. He faces a sentence of 10 years in prison if convicted.
Joining us live now from Florida is Court TV legal correspondent Kelly Craft. Kelly, this trial was expected to begin today. It did not. Tell us more about what happened, please.
Well, hi there, Judge Ashley and Michael. Yes, it was set to begin today, so our Court TV cameras came down here to set up for this trial. But then some unexpected news took place. We had heard that there possibly was a plea agreement that had been reached, at least according to the attorneys and maybe between the attorneys. But then when that plea agreement came to the defendant, he did not accept it. And so he told the judge that he was not going to accept that plea agreement. The negotiating plea would have dropped the top charge of manslaughter. He would not have had a felony on his record. The offer was 10 years probation on the two lesser counts, battery and carrying a concealed firearm. But yeah, he told the judge that he wanted to go to trial on this. So why we didn't then go to trial today is there was a conflict with some of the state's witnesses. In fact, the chief medical examiner on the case, he's now retired, there was a conflict with his schedule, and so then the state could not proceed, at least with some of its witnesses. So the state came up with some sort of arrangement where maybe defense counsel could go first, present any kind of case or evidence that he might have. So there was some back and forth discussions as to how we could get this trial moving forward today. But then the judge said that he had some situations that were coming up on Thursday and Friday, and so he would rather that we wait and not proceed with this case today. But a lot of questions are looming as to why the defendant in this case did not accept this plea arrangement. And so when you take a look at what the state wanted him to do, he is claiming that this was a case of self-defense. He had a stand your ground hearing a while ago. He was unsuccessful in that stand your ground hearing, and so the judge said that he would have to go to trial and a jury would have to decide. And so this plea offer would have given him not a felony. He would not have had a felony on his record, taking off that manslaughter charge. But again, from Deltoro's perspective, this was self-defense, and so even to say that he committed a battery is not something that it appears that he wanted to even have on his record, because in order for a state to prove the battery, it has to say that this was not in self-defense. Well, he's claiming this was self-defense, and he wants to have his day in court and tell this to a jury.
Yeah, that is quite a gamble. I gotta say, that is quite a gamble. He must
Agreed.
feel very, very strongly. All right, Kelly, you talked about the idea it didn't go today. We know that happened. Did they set a new trial date?
Michael, they did, and so September 10th is expected to be the day when this case will end up going forward. The state has already said that it's going to be a short case, that they expect to call only about 4 witnesses, and then it would appear that maybe Del Toro will end up taking the stand. We don't know that for a fact, but again, if he's claiming that this was in self-defense. So really what he says is there was this altercation with his father in the vehicle, but that was just an accident as well, because he accidentally hit his father, according to some police reports. He's saying that he accidentally hit his father first, and then the father became frustrated, agitated. Then when they got back home after celebrating his 28th birthday, the altercation ended up continuing, and then the mother successfully was able to kind of break it up, but his glasses fell off during that altercation, and then according to some police reports, he cannot see, the defendant cannot see without his glasses on, and then that is when he shot his mother. At a prior hearing, the judge really just summed it up about there's no words for this case. We are here because the mother is deceased. So we're gonna have to wait and see what happens when this trial does move forward September 10th. Michael and Judge Ashley.
All right, Kelly Graff, thank you so much for your great reporting live from Florida. Michael, I must ask you, former defense attorney that you are, to hear, number one, that he lost his stand your ground hearing, so that's out the window. He would not have a felony, 10 years probation, no jail time. Wouldn't you tell your client to jump at that?
I would have absolutely told them to jump at it. But again, you're at the mercy of your own clients. It's up to them whether they take it. You can tell them from every day till Sunday, you should take it. This is a fantastic deal, which is what it was.
Yes.
No time in jail under these circumstances, I think, is a fantastic offer. It may say something about the state's case as well, what they feel they can prove in court. But at the end of the day, the fact that he didn't take it says he feels strongly about his self-defense claim.
I agree. I think that is it. He's emotional based because he says, no, it was self-defense. Let's bring in our guest for this hour, national trial attorney David Yenna. David, weigh in on your thoughts on the plea deal that he turned down and his assertion that this was self-defense. I should not be found guilty.
No jail time and no felony on his record. It is quite shocking that he did not take that deal. So I think, as Michael said, it plays to perhaps the strength or the lack thereof, the strength of the state's case. You know, everyone has a constitutional right to defend themselves, and if he feels he does nothing wrong, it's his right to go to trial.
You know, you would have to, David, I would think, explain to him that you have to be in fear for your life. He tried to claim that at the stand your ground hearing. It didn't stick. The judge decided it didn't apply in this case. Doesn't mean he won't be successful with a self-defense claim, but what do you think his chances are under the circumstances? He claims he thought his father was reaching for a gun. I don't believe, according to the arrest report or the incident report, that a gun was found anywhere at the scene. It's his word against his dad's.
Definitely, that's the tough part. The fact that there was no gun on the scene. I mean, they're going to have to present evidence that his father often did carry, or he had good reason to believe he may have a gun in his pocket and reach for it. I mean, his glasses being off is another factor here, and whether he could actually see what was going on, whether the history between his relationship with his father, whether he felt threatened him in the past. There's a lot that needs to play out for him to tell his story here to make that self-defense defense really work.
And never mind, you know, the horror of the fact he just shot and killed his mother, the victim in the case. How much does it play into a trial that it was his own mother who was trying to help that he shot and killed, allegedly? Well, we know, let me just say, though, we do know he shot and killed her. It's whether or not it was self-defense.
Right, yeah, I think sadly enough that helps him, right? Because she was not the aggressor and she was a victim, and I think you're going to be able to play into the heartstrings that he had no intention of doing this, but he was in fear of his life rather than, you know, he shot the actual aggressor here. I think that actually helps, in my opinion, in the jury's mind.
Yeah, I think what also helps, Judge, is the fact that I believe, according to his statement to police, and again, it's going to be Dad's word against his, was that at some point when Mom was trying to break them up, he was kind of assaulting Mom as well. So you sort of add that into the mix. A jury may look at this thing and say, you know, we certainly understand how he responded to the situation.
Yeah, it's an interesting case for certain.